I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Nash v. Califano, a Second Circuit Court of Appeals decision from 1980 that helps us get a better understanding of administrative law judges. They come up a lot in administrative law and in the cases we study, and we're studying this case to get a better understanding of who these people are and what they do. So let's look at what happens in this case. Our main takeaway here for the case is not about the kind of black letter law or doctrine it sets. It's actually just a case about whether someone has standing. That's the issue on appeal. So it's not really an important case for precedent. But it gives us, though, a useful glimpse into practical aspects of ALJ independence versus the agency's attempts to kind of control the outcomes in some of these cases. It's also useful for understanding the agency's agenda in an important case, Heckler v. Campbell, which is in a lot of administrative law casebooks. It's important for understanding the development of administrative law. So again, this case wasn't important for developing legal doctrine. It's important because if you read the case and look at what's going on, you get a clearer understanding of who ALJs are and how they work. But let's meet the parties. I'm sorry I can't find a picture of ALJ Nash, but he was an administrative law judge for the Social Security Administration. And he, at the time of this case, he would have been in his 60s. He had already had a long career and knew what he was doing, was well settled. And he was unhappy with some new policies with the Social Security Administration. And Social Security is under a department of the executive branch, which at the time was called Health, Education, and Welfare, or HUE. It has since been renamed HHS, or Health and Human Services. And at the time, Joseph A. Califano Jr. was the secretary of HUE, which meant that he ended up being the named defendant in the case, even though he wasn't really involved in the litigation or the actual problems that Nash was encountering. But because Nash was really upset about a bureau within the Social Security Administration, and then Califano is the secretary of the agency that's over the bureau that Nash is suing. Now, here's Nash's theory. Nash says that these management policies actually infringed on his rights as a judge, statutory, regulatory, and customary, to be an independent decision maker. And if that sounds like a novel idea to you, that a judge can say, hey, wait a second, I need more freedom to do my judging and make the right decision in each case, and I'm going to sue you if you try to kind of restrain me or put constraints on me. Well, the district court agreed with you and said that Nash is an ALJ, so he lacks standing to sue, and Nash appealed. Well, the surprise is we get to the Second Circuit, and the Second Circuit at the time held that an ALJ actually does have standing to challenge an alleged infringement on the ALJ's right to decisional independence. And we'll get to the why in a minute. Not all of his claims were successful. At the same time, Nash lacked standing to object to certain proposed plan changes and some superficial changes in titles and functions at the Appeals Council and the regional chief ALJs. Again, you don't need to worry about that right now. Just understand that some of his claims didn't have enough merit to even warrant giving him standing. Now, I pulled some pictures from the Social Security Administration's website. They have a guidance document that's best practices for ALJ hearings that have some sort of older pictures of these hearings. And this is helpful. In law school, it's easy as a student that you get a picture of how trials work because we've seen them in movies and TV shows and stuff like that. So you're used to seeing courtrooms. But this is a very typical ALJ hearing room where you do have a bench, an elevated bench that the judge sits behind. A lot of Social Security ALJs will wear a black robe for their hearing. There's usually a court reporter off to one side, as in this picture, and then a conference table, or sometimes two small conference tables, where you'll have the claimant or the petitioner, who's, I assume, is seated at the far head of the table with their lawyer, and then a couple other people who are probably there to testify as medical experts or vocational experts, is my bet. Now, these ALJ hearings are not in a courtroom, right? So we don't have a gallery and benches and a jury box and stuff like that. They're kind of in a little conference room with a place for the judge to sit like that. So it's less formal than a full-blown trial, but there are formalities. For example, witnesses are put under oath to testify, and there's a court reporter or trial transcripts, hearing transcripts created. This is another picture of a pretty typical ALJ hearing room. Again, you might have a table or two like this with the lawyer and the party and a court reporter, and then someone there who's to testify on one side or the other, or even as a neutral sort of medical advisor for the court. Now, this graph I took out of the casebook, and this illustrates what the Social Security Administration was upset about that prompted some of these policies. So take just a minute and look at this, if you would, and see what's going on here. The data here is from the late 70s, but this problem doesn't go away. And the problem is that, so first of all, this tells you kind of how many ALJs or the percentage of ALJs who are granting benefits and how much of the time. And so if you look at this, you'll see that there's two bands that go all the way to the top at 52 to 56% and 56 to 60, which means the most common sort of decision rate for administrative law judges is actually to favor the claimant and reverse the denial of benefits a little more than half the time, right? So between 50 and 60%. And Social Security would like to move the whole graph a couple spaces over to the left and have the top of the bell curve be really nicely centered at exactly 50%. But the bigger problem is these outliers at the far ends on each side, or the tail of the graph. So on the far left, we have the Grinch, right? So this is someone who is denying benefits when they do hearings, issuing a negative decision about 90% of the time, right? So if you are applying for Social Security disability benefits because you've been injured and you can't work anymore, and your case gets assigned to that ALJ, you are going to lose, right? It's 90% probably that he's going, all things being equal, that he's going to rule against you. And then on the far right, we have a couple people who are basically benefits fairies. So it's almost the ratio is almost flipped, where you have 85, almost 90% chance of winning. That's how often they grant. And this made the Social Security Administration upset. And I can tell you from when I was in practice as a legal aid lawyer, who your case got assigned to mattered, right? And in terms of what the outcome was going to be after your hearing. This is a graph that I adapted from an article in the Texas Law Review that came out in 2017. That just to give you a picture of the numbers here of how many ALJs and cases there are. So by far, most of the ALJs are in the Social Security Administration and most of the hearings. So there's a reason to pay special attention when you're doing Social Security cases in your administrative law casebook. All things being equal, they're by far the most common cases or things you would encounter in practice. So you can see that SSA in 2013 did just under 800,000 formal adjudications nationwide, whereas other agencies did far fewer than that, right? The EOIR did about 250,000, and then we have some that are even less than 2,000, like HHS provider reimbursement boards. And the number of ALJs that the agency employs basically correlates to how many hearings they're doing. So the SSA does almost around 800,000 a year. Sometimes it's more. It starts to inch up toward encroach on 1 million cases a year nationwide, and they have around 1,500 ALJs. And so that means, regardless of the agency, ALJs are cranking out hundreds of hearings and decisions a year. They're holding hundreds of hearings every year and writing opinions for all of those cases. So as you can imagine, Social Security is worried about backlog, and that the judges are going to get way behind if they're supposed to be writing 60 opinions a month. And so they set up, at least in Nash's region, a regional office peer review program that sidestepped the normal appellate process. So normally, if you are dissatisfied with the result at your ALJ hearing with the agency, depending on the agency, you either get to go right into federal district court to seek judicial review, or you might have an intermediate step in the like in the Social Security Administration, where it stops at the appeals council, and then you go into federal district court. But instead, so that's where we would be evaluating on the merits. But here, under this program, we're outside of that process. We have administrators and office managers and staff that are giving the ALJs detailed instructions that Nash thinks are mandatory about proper length for how long their hearings can be and how long their opinions should be. They're basically telling them, look, you have to do 600 hearings a year, which means you need to do shorter hearings and shorter opinions if you're going to get it all done. Don't spend so much time. You don't need that much evidence or have to go on and on analyzing each article of evidence or item of evidence or exhibit, and stop calling so many expert witnesses, because it just makes everything longer and more complicated. His second claim was that there was a monthly production quota for the ALJs. So basically, Social Security wanted them to stay on task and get a certain number of done every month. And if you didn't, they would at least threaten to file incompetence charges with the Civil Service Commission. Now, there are some other academic research articles out there about courts that indicate when courts are overwhelmed and have to issue rush decisions, that quotas, basically any type of quota like that, means that we're going to have rush decisions, and denials take less time as a general rule of thumb. So an unfavorable decision for the petitioner takes less time for hearings and writing the decisions and so forth than a favorable one, just all things being equal. So a production quota, in other words, does in the aggregate seem to have an impact on outcomes. His third claim is that there was this quality assurance program, and this is kind of egregious, right? The Social Security is basically just trying to boost the number of denials, right? They want fewer people that they have to pay benefits to. So they spread the word, according to Nash, let it be known that there's a national average for a 50% reversal rate, and they expect everybody to be kind of on that average, right? And so if you're above average or below average, they want you to get on board and get with the program and try to average out your cases, so that for every case where you're granting benefits, you're denying benefits in another case. And so allegedly, the Social Security was starting to monitor these ALJ grant rates, or which are called reversal rates, and warn people who were being too generous, who were above the national average. Then he had a couple other claims that were a little bogus, right? So Nash said that there was this kind of new employee pool system that transferred some of his judicial responsibilities to clerical staff. And so, in other words, clerical staff would take a stab at writing a draft opinion and things like that, which made him really mad. And that there were some changes with the appeals council and the chief ALJs with titles and functions and so forth. And neither of these were really valid, but some of his claims were. And how do we get there? How does a judge have standing to say, you're not allowed to interfere with my judging this much? Well, they say it's because of a statute. And this is the Administrative Procedure Act, or the APA. Congress enacted Section 11, the court says, of the APA that removed the agency's control over ALJ or hearing examiners' tenure. So they can't basically fire people because they're granting too many people benefits, nor can they dock their pay or keep them from getting raises, right? So they can't control their tenure or compensation. And instead, that's been vested in the Civil Service Commission. And ALJs are a little unlike other civil servants that are under the Civil Service Commission, because they can't be removed without formal adjudication. And so the court thinks it's clear from these statutory provisions that they confer a qualified right of decisional independence on ALJs. And the Social Security Administration itself had put out some internal regulations that the court here says basically limit the agency's powers over ALJs even further. I pulled out a quote for you that summarizes or kind of captures an important part of the reasoning of the court. The APA, that's a statute, provides that ALJs are entitled to pay prescribed by the Office of Personnel Management independently of agency recommendations or writings. In other words, they did not want people to get paid more based on how fast they were at making decisions or get their pay docked if they granted too many people benefits. The APA also exempts ALJs from performance ratings prescribed for other civil service employees. ALJ tenure, moreover, is specially safeguarded. And then, so given the things that Nash is saying that they're doing, the scrutiny in affirmative direction reaches virtually every aspect of an ALJ's daily role. The number of reversals, the number of dispositions, the manner of trying and deciding each case are recorded and measured against prescribed standards. And if true, these would be unlawful instructions regarding every detail of their judicial role. Now, do remember a couple of Nash's claims failed. His gripes about the employee pool system, well, this was too new. It had only been implemented in one office, if I remember right, and it was experimental. There was no indication that Social Security was going to continue it or that it had created any harm yet or would create ongoing harm. He couldn't prove it. And the changes in titles and so forth for the regional directors and ALJs, he couldn't really show how that had harmed him. Now, where does this leave us? Well, administrative law judges usually pride themselves on their fairness and objectivity and independence. They are not supposed to favor the agency in their decisions. And I would warn you when you're in practice, do not tell an ALJ that you think they're biased because they work for an agency. They're likely to feel indignant about that. They are bound to apply the relevant statutes and agency regulations to the cases before them. They're not free to just do whatever they want or flip a coin, right? They have to apply the law, but they are their decisions are independent of the agency, which means they're not supposed to be under pressure from the agency. Now, the flip side of this is that agencies are worried about ALJs favoring individual claimants over kind of the big impersonal agency. So they're worried about ALJs being too generous. And they're also reasonably worried about inconsistent results, right? If you have a case, your case should be decided on the merits. Are you disabled or are you eligible for benefits or not? It shouldn't, the outcome shouldn't depend completely on which ALJ you get assigned to. So if you get assigned to the ALJ who doesn't think anybody should get benefits, you're out of luck. And if you get assigned to an ALJ who's generous, then you're going to win. The agencies are kind of right to worry about that. And so we have this is still going on to this day, this type of kind of tension between the agencies and the ALJs, especially in the Social Security Administration. And that concludes our lecture about Nash v. Califano and administrative law judges.